We're now getting into topic 8, and just a heads up, topics 1 through 8 are the topics that will be covered on the midterm exam. Okay, we're talking about forms of business organization, and there are 3. Everything else is sort of a subcategory or a hybrid of one of those 3. I read a management textbook one time and it talked about 14 different forms of business organization, and I went, oh my God, I'm negligent, I haven't been keeping up. And then when I went back through there, they talked about sole proprietorships, of course, partnerships, which is the second one, and then they had limited partnerships, limited liability partnerships, joint ventures, strategic alliances, which are all just partnerships, okay? And then they got into corporations, and they had wholly owned corporations, subsidiary corporations, partially owned corporations, and then they had employee-owned corporations, private corporations, public corporations, and it all boiled down to 3, okay? Sole proprietorships, partnerships, and corporations. Looking internationally, in civil law jurisdictions, every business organization is referred to as a company. So it's very difficult to discern when you're talking to a business person and they have a sole proprietorship, a partnership, or a corporation. So that's the first thing to keep in mind. In civil law partnerships, a company of 2 or more persons who co-own and manage a business for profit and who are fully liable is the definition. There are subtle differences, though. For example, in France, a partnership is considered to have a separate legal personality and can own property in the partnership name and can elect to be taxed as an entity. Not so in our civil law jurisdiction, and we'll talk about that in a minute. In Germany, a partnership does not have a separate legal, is not considered to be a separate legal entity, and the partners own assets and are taxed as individuals. That's very, very much the same as in Canada. And then I put a note on slide 88 where it talks about partnerships and companies are referred to as société en nom collectif or a société en responsabilité limitée. Whereas in common law jurisdictions, we have separate non-business entities called societies. Okay, so they have a society collective, which is just a society, and then the society a responsibility limitée is like a business partnership. Okay, there is an article of partners and partnerships. It's a really interesting article. I'm going to post it on eLearn. What it was a partnership in Quebec owned, the partners owned property. And one of the partners wanted to leave. And so the question then became, is that being property sold or is he selling a portion of the partnership? And so they had to decide whether a partnership was a separate legal entity that could own the property or whether it was just 3 individuals or 4 individuals that owned the property. And the interesting thing about the article was this is a civil law concept, of course, and they went right back to the Roman civil code, okay, drafted by Justinian, and looked to see what that was like. And then they looked at France and the fact that the France partnership could own property, and then they looked at Quebec. And because Quebec was a colony of France, and originally they thought, okay, well, perhaps then in Quebec a partnership could own property separately. And they looked at the old Quebec Civil Code and they looked at the new Quebec Civil Code. And the bottom line is, and this is what's important to keep in mind, is that a partnership is merely people. Okay, it does not have a separate legal entity like a corporation. So the people own the property, and if the property is sold, then they are taxed as individuals. They don't have the ability to have that sale taxed in the partnership itself. Civil law limited liability company is a separate legal entity owned by persons called associates. So this would be the same as a private company in British Columbia. Because the interests are not sold publicly and the financial statements need not be disclosed to the public, which is very similar to ours. Now, note, associates own part participation or quota. Okay, they do not own shares. And this can be really confusing when you're dealing with a counterpart in a civil law jurisdiction, and he says, I own part of the company, and you go, well, how many shares? And you go, well, I own 12 parts, and you're going, what? Or I own quota in that, and you go, quota? Isn't a quota like how many items you have to sell? So it can be really quite confusing. A civil law stock company is a publicly traded company. It's a separate legal entity owned by persons called shareholders. Okay, private corporation, they're called associates. In a public corporation, they're called shareholders. And the shares are freely traded on the stock exchange, and the financial statements have to be disclosed. Okay, now one really significant difference between the civil law jurisdictions and a common law jurisdictions is, in a civil law jurisdiction, the shareholders or the associates declare dividends. In a common law country, the directors declare dividends. Okay, and that'll crop up in the exam, I'm sure. In common law companies, not all businesses are referred to as companies. Some are referred to as sole proprietorships, some are referred to as partnerships, and then we get a little sort of confusing area between partnerships and corporations. And that is, there's no law that says you cannot use the word company. So ABC Manufacturing Company pardon me, may be a sole proprietorship, a partnership, or a corporation. For example, we have the Hudson's Bay Company, which is definitely a corporation, but a business ABC Manufacturing Company may not be a corporation. So there's no prohibition against using the word company. You cannot use the word corporation. Okay, that indicates that you have been incorporated. Okay. Now, how can the Hudson's Bay Company be a corporation when our BC Business Corporation Act says that a corporate entity must end in Inc., Corp., or Ltd? That's because when the Hudson's Bay Company was incorporated, it was back in 1640, and we did not have a Company Act or a Business Corporations Act under which private people could incorporate. What happened at that point was the person that wanted to run the fur trade in Canada needed thousands and thousands of investors, and so he didn't want to have a partnership because thousands and thousands of partners would be chaos. So he went to the king and he said he wanted to be formed into a new type of business organization called a company, and explained why. And the king said, "What do you want to be called?" And he said he wanted to be called the Company of Adventurers and Explorers. And the king said, "Thou art one." Bingo. And it became a company, and then it changed its name to the Hudson's Bay Company, and that was totally acceptable. We could still do that today. If I wanted to form the Peter J. Holden Law Company, I could, if I had access to the Lieutenant Governor, who is the Queen's representative in Canada, I could go to the Lieutenant Governor and say, I want to be formed into a company called, a corporation called the Peter J. Holden Law Company. And the Lieutenant Governor could say, "Thou art one." The problem is we don't have access to the Lieutenant Governor provincially. No one has access for that reason to the Governor General of Canada. Okay, so we now incorporate businesses under the our new updated statute called the BC Business Corporations Act. Okay, and now those businesses have to end in Ltd, Inc., or Corp. All right. Okay, common law partnership, two or more persons working in concert with a view to profit. and having unlimited liability. Sole proprietorships have unlimited liability. This is, and then it says partnerships have unlimited liability. In actual fact, it's my opinion that you have more liability in a partnership than you do in a corporation or in a sole proprietorship. In a sole proprietorship, if I have a sole proprietorship, which I did in my law firm, I live with the possibility that I may make a mistake. Okay, but I can live with that possibility because I have control over whether or not I make a mistake. And I also can take risk management steps, all right? Get insurance and that sort of thing. When I'm in a partnership, if it's a general partnership, the problem I have is that I have liability, unlimited liability. It's called joint liability with my other partners. But I also have more liability because if one of my partners is negligent and has made themselves judgment proof, or it's so serious that they take off and go to Brazil or somewhere where we don't have an extradition treaty, but I can't leave Canada, well, I'm only responsible for what, 1/3 of that liability? No, I'm responsible for all of it. I'm jointly and severally liable. Okay, I'm jointly liable for the debts and obligations, that's fine, and I'm jointly and severally liable for the negligence of my partners. So my liability extends beyond my ability to control. Even though on screen 100, it says unlimited liability, in fact it's joint liability and joint and several liability. In British Columbia, we have a Partnership Act, and it allows limited partnerships, which means that there are one or more general partners who are jointly and severally liable for the debts and obligations of the business. But the other partner might invest money but become a limited partner in the sense that they are not responsible for the debts and obligations of the partnership other than what they invest. So I can become a limited partner and put on $100,000 into your partnership, and there's 3 of you. You're jointly and severally liable, but I have limited liability in the sense that I can only lose what I invested, sort of like buying shares in a corporation. You have to keep in mind here that jurisdictions are different. Okay, so partnerships in civil law countries, I don't know, okay, because I don't practice that kind of law. But I can tell you that within Canada, excluding Quebec, I know of differences between provinces. In British Columbia, I can become a limited partner. But Section 64 of the Act says I cannot get involved in management. What's that mean? Well, I invest the money and I have a marketing background, and the 3 partners say, okay, now we've got the money we need to bring our partnership to the next level, but we need a marketing plan. And none of the partners know anything about marketing. Wait a minute. Peter Holden, our limited partner, was in marketing. So let's get him to do a marketing plan. Well, the second that I do the marketing plan, I've become involved in the management of the business, and I lose my limited protection, and I become a general partner, and I have joint and several liability. Okay, that's 64. But that's BC. It says management, take part in management. In Ontario, the exact same section, a different number, but the exact same section says you would not be liable as a general partner unless he or she is involved or is in control of the partnership, involved in the control of the partnership. It doesn't mean I have 51% or 60% and I'm in total control. What it means is I'm in a position to actually make strategic decisions about the partnership. I found this out because I had a student graduated and he had connections with Cuba. And there was a company in Ontario that did a number of magazines on various countries. And they wanted to do one on Cuba. And because he was familiar with Cuba, they asked him if he would take the editorial position to do that magazine. And he said, I want to invest, but I don't want to become a general partner with unlimited liability. And so I checked the statute, and there he had no control. He did not make decisions to the partnership. When they had a decision about this and that and the other thing, he was not one of the people that would be involved, but he would be a partner. So as a limited partner, because he was not in a position of control, he could actually work for that partnership and be involved in the management of the Cuban magazine section. That kind of distinction is important, and for example purposes, I might be able to get that on the exam somehow. Okay, looking at common law private corporation, this is what most of us will have. I mean, I've had one in the past, and I've now let it go, but you have it for a business purpose, and the key things here is that you cannot have over 49 shareholders. Most of them only have a few shareholders, 1, 3, 7, 9, something like that. If you go over that, then you have to go public, and there has to be a restriction on the sale of the shares. Now, just gonna, 1 second here. I grabbed what I thought was a corporate minute book, and in fact it's not. But a corporate minute book looks somewhat like this. Okay, so you think of Exxon as this corporation in New York with this big building and lots of money and everything, but it's actually just a book like this on a lawyer's shelf. Well, in here there is going to be articles of incorporation, and those articles are what is generally used to restrict the sale of shares. And what will happen is, towards the end, it will say, and the shares and no shares shall be purchased or sold without the consent of the directors. Okay, and that's a sufficient restriction. Public corporation, shares traded on the stock exchange, and there's no restriction on the number of shareholders. In Canada and the United States and Great Britain, directors declare dividends. Okay, that's where I'll take a break because I'm going to go and have some lunch. All right, back after my lunch. I see a big break because I move away, but of course the video just continues, so you probably don't even notice. Anyway, on slide 103, there is an incredibly important diagram. The use of a corporate entity is a risk management strategy that proves very, very efficient. For example, I have a client right now who, because of COVID-19, his corporation is going insolvent. The corporation goes insolvent, he just closes the door and walks away. The landlord doesn't have rent, can only sue the corporation. The creditors, if there are any, can only sue the corporation. So that the corporate structure is very important for that. It limits the losses to the corporation itself because you cannot pierce the corporate veil and make the directors, officers, or shareholders liable. The diagram on that page shows the corporation with 4 shareholders. It could be 2 shareholders, 1 shareholder, 10 shareholders, doesn't matter. But those shareholders are protected from liability because of 2 sections of the BC Business Corporations Act. Section 30 says the corporation is a separate legal entity, having all the powers and capacities of a natural person of full capacity. So it becomes a distinct personality, a judicial or a juridical person. We've seen that term earlier on. The use of a corporation by private individuals to limit their liability would be totally useless if the shareholders were protected but the directors and officers weren't. Now, the corporate veil, and that's a term that was invented by a judge in the late 1800s when this whole concept of the corporation as a separate legal entity was being analyzed by the courts. The corporate veil of protection can actually extend further up and protect the officers and directors. But that protection does not come from a statute law, it does not come from the BC Business Corporations Act. It comes from agency law, which is common law. Okay, and so that's one of the important factors, and we're going to come back to that in a minute because I want to dwell on it. But the other advantages of a corporation, and it turns out that there's quite a number of them, and so this is a potential Part B exam question. There's the limited liability, which we've always talked about. Then there's the continued existence. A sole proprietorship comes to an end when the sole proprietor passes away. Okay. Now the business might be sold and continue in that respect, but that business comes to an end. A partnership, when a partner dies, that business comes to an end. Okay. Now the partnership can continue in name, but the accounting has to be closed off and new accounting has to be done because the partnership changed. There's no loyalty by the or good faith owed by the shareholders to the corporation. So I can invest in the Bank of Nova Scotia and I can invest in the TD Bank. And, I'm invested in two banks, I have a conflict of interest. No, I don't. Okay, directors and officers, if they worked for two different banks, would have a conflict of interest. But shareholders, no, because we owe no duty of loyalty or good faith to the corporation. And then it's possible that the corporation will provide a tax advantage. Okay, and here you have to talk to an accountant. Basically, very early on in your career, when you start hitting $140,000, $150,000 a year in salary, you're paying taxes somewhere between 55 and 65%. Well, you can form a corporation, a Canadian-controlled corporation, which is taxed at a substantially lower amount, and then you can take dividends, which are taxed at 17%. And you can offset some of that tax. So there is a potential for a tax advantage. Also, you don't have to take all the money out of the corporation. You can build up a cash reserve in the corporation, and then when you decide to retire, you sell the assets of the corporation, but you keep the corporate entity, and the corporate entity is the one with the cash in the bank. So then you can continue for years as a director of that company, giving yourself dividends as a source of income. All right, piercing the corporate veil. I'm going to put a diagram on Moodle, and we're not going to spend a lot of time on this, but basically over the years the courts have said, hey, there are various reasons why the people involved in the corporation should be held liable, either civilly, okay, for damages, or quasi-criminally, so you get fined, or criminally you get fined and or put in jail. And I put that on there just for your edification. The one thing you have to walk away from that is, well, let's put it this way. You look at it and you go, whoa, if there's that many ways that the corporate veil can be pierced to make the directors and officers liable, why bother incorporating? And you have to look down the list and realize that there are two things that are not on there which are incredibly important for protecting the directors and officers. And that is torts, okay? Nowhere on that list are there any torts. Now, criminal negligence. Negligence, that's a tort. No, criminal negligence is a crime, okay? So there's no, negligence isn't on there, product liability isn't on there, defamation isn't on there, the economic torts on there, misappropriation of personality isn't on there. So and torts are one of the serious potential liabilities for a corporation. You make a product and it turns out to be negligently manufactured by one of your employees, that employee is liable, okay? But as long as you hired the employee and as long as you supervise them, they make a mistake, they're liable, okay? So the corporation is vicariously liable for the torts of the employees. Oh, no, there we go. Well, they can't go through the corporation, though, and go after the directors and officers. So the fact that torts aren't on that list, really important. The other one is contracts. Contracts with your customers. 600,000 products get returned and they want their money back and the company goes insolvent, but you, as the director, don't have to pay for that. Now, I was talking about my client who is on the verge of former client, because I'm retired, is on the verge of bankruptcy, and one of the biggest liabilities of his firm is paying the lease. Okay, so the landlord is going to be on the hook because the corporation has no money, the rent doesn't get paid, the landlord cannot pierce the corporate veil and go after my clients. Right at the bottom of that list of things that I've posted, it says covenants. Well, if you want to have your corporation rent premises and the landlord says, okay, I will rent the premises to your corporation, but I want you to sign a covenant that you will be personally liable if the corporation cannot pay, you sign that covenant under seal, then they can pierce the corporate veil and go after you. But if you structure your business affairs appropriately, that won't happen. My client is older and he's going to wind up his corporation in a few years anyway. But when he was at his busiest, he had 4 locations. He had 4 premises in 4 different buildings with 4 different landlords, and not one of them had a covenant from him, because he had a substantial business and he said, I want to rent premises. And they would say, we want a personal covenant, please. And he would say, nice talking to you. I'm going to go and rent that building because they won't need one. And that landlord says, oh, okay. We'll rent to you or to your corporation and we will not require a covenant. Okay. If you sign a covenant, you're on the hook. Okay. It's that simple, but you don't have to do it that way. So, the fact that there's contracts both with suppliers and customers and the potential of tortious liability means that the corporate entity is still a very good risk management tool for shifting a potential loss from you to the corporate entity. Now, right at the bottom of screen 104, there's a risk management consideration, and that is, in order to not have the corporate veil pierced, you have to do your due diligence. You have to be able to rely on the due diligence defense. What's that mean? All that really means is you have to run your business as a prudent individual would do. Okay, so if you run a business and you hire poor employees and you don't supervise them, if you run your business and you sign covenants, if you run your business and you have no quality control, if you run your business and you don't monitor profit and loss, you deserve to go insolvent. Okay, and you deserve to be personally liable. But if you have profit and loss statements, so you monitor whether your business is doing okay, and if you hire good employees, and if you train them properly and supervise them properly, if you have quality control management to the best of your ability, then you've done your due diligence. Okay, and you will not be personally liable. They cannot pierce the corporate veil and go after you for any of those things on that list. All right. So that's one of the key factors. Now, what does due diligence involve? Obviously, it involves complete management of your corporation. But one of the key factors was making sure that when you're dealing with people, they know that they are dealing with a corporation and they're not dealing with you personally. And this gets down to the signing of emails, letters, invoices, and contracts, okay, and even your bank checks, okay, if you still pay by check. Okay, so how do you do that? Well, on screen 105, it shows you how a corporation signs. And it's ABC Manufacturing, and right below that there's a line, and on that line it says per, and underneath it says authorized signatory. This comes from case law. Okay, there's no statute that says this is how you do it. It's case law, judge-made law. And I found two cases in the province of British Columbia where judges said if you do not sign that way, you will be personally liable. So what does per mean? It means on behalf of. Write that down. On behalf of. It means you're signing on behalf of the corporation. If you're signing on behalf of the corporation, you're not signing to be personally liable yourself. Authorized signatory right underneath is in the world according to Peter Holden. Okay, the judges did not say, oh, you have to have authorized signatory down there. No, they didn't say that. They said you had to have the per. Okay, in the world according to Peter Holden, put authorized signatory under the line. And because what does authorized signatory mean? Oh, am I an authorized signatory for me? No, I'm me. Okay, I might be an authorized signatory for someone else. I could be an agent for somebody and have a warranty of authority so I could sign for them. But in a corporation, if I'm an authorized signatory, what that means is I am acting as the agent for the corporation. Okay, so it's one more nail in the coffin that will prevent the judge from finding you personally liable and piercing the corporate veil. Okay. And for years and years and years, I was saying, put down authorized signatory as well as per. And other lawyers that I talked to said, oh, yeah, it's not really necessary. I'd do the document for a contract between his client and mine. And he'd say, what did you put authorized signatory? I said, just, for safety. And he said, well, it's not necessary. I went to a continuing legal education seminar, which we had to do periodically as to keep up our skills as lawyers, and it was on contracts. And the Law Society brings a lawyer from Atlanta, Georgia, all the way up to talk about contracts and signing contracts. And I was sort of aghast at the way they waste money, because there must be at least one lawyer in Canada and maybe at least one lawyer in BC that could have done that, right? No, they have to bring someone in from Georgia. But that was okay, because halfway through the presentation, she said, oh, and you should probably put authorized signatory under there. I always do. And I went, yes. And she went, what? And I said, oh, no, thank you, because you vindicated me. Because I always recommend that you do that, okay? So on the exam, if it's there, it'll say something like, what's per mean? Why is authorized signatory required in the world according to Peter Holden? And if there's going to be personal liability, for example, if you're getting money from the bank, there is no way you're going to get around providing them a personal guarantee. Then there has to be another line with a seal beside it. All right, we had some case studies with respect to corporations. One was the Barcelona traction case where the shareholders from the Netherlands tried to sue, and they could not do that because the directors had to do it. The other one that is mentioned on slide 106 or 5 rather, is one that we haven't discussed, but it's one that we did in BADM 107, or you should have, where it was the very first case where the existence of a separate legal entity was challenged in the United Kingdom. And it went all the way to the House of Lords, and the House of Lords said, in the statute, it says that the corporation is a separate legal entity. Well, it either is or it isn't. And if Parliament wanted them to be a separate legal entity, but the directors are liable, or a separate legal entity, but the shareholders are liable, they would have said so. But no, they said it's a separate legal entity, and ergo it is. And that was the leading case. And in 1983, I was working as an article student, and a lawyer had to go to court, and he said, Peter, quickly note up Solomon versus Solomon and Co. And what he meant was find out if it was still current. And I went back and went through all the cases, and it is still good law today. All right, so the next topic after this is contracts. But that falls into the latter part of the course and will be a subject for the final examination. So we have now concluded all the material that will be covered on the midterm exam. Following this video, there will be one where I go over last year's midterm exam in preparation for you to do this year's midterm exam. There will be a slight change, okay. Last year we had 3 hours, and so I gave questions that could be answered within that 3-hour time limit. This term we have 3 hours, but instead of just saying things like list the 6 binding elements of a contract, or something like that, I will probably say list and explain, because last year they had to actually remember because it wasn't open book. This year you can go and look it up. So I think what I want you to do is not only be able to look it up and list them, but look it up and give me a little bit more than that. Okay, that's fine. That's all on this video. All right, now this is another little add-on video with respect to forms of business organizations, or the multinational corporation. I grabbed a binder earlier and I thought it was a corporate minute book, so I just wanted to actually grab a corporate minute book and talk to you about it briefly. This is a corporation, one of the active corporations that I had as a client. When you open it up, there's a tag that shows a wonderful document called a Certificate of Incorporation. That's the birth certificate for a corporation. That's the day it came into existence. There can be a name change certificate, just like you can change your name. The corporation can do that. Then there's a notice of articles that are filed. And what this does is it lists all the various different kinds of shares you can have. You can have common shares, common voting shares, common non-voting shares. You can have preferred shares. Preferred shares where an investor invests in the company, doesn't want to be involved in the management, and gets some preference as to dividends being paid first to him or her, and return on capital and things like that. Then there are numerous other divisions in here. The most important one is the Central Securities Register, which just lists the owners of the shares and their addresses, because that's public information that people have to know. Then there's one called Documents filed with the registrar. Every year the corporation has to do some documentation in order to keep the company in good standing. Okay, now good standing. I'm writing that on the whiteboard. That's a term you have to know. Good standing. When a business or a corporation is up to date with its filings of its annual report, having its annual general meeting of the shareholders, annual general meeting of the directors, then it's in good standing. As a lawyer, I handled 30 or 40 companies, and every year I would keep them in good standing by filing their annual report. Their annual report, remember, is in a private corporation, is not financial statements. It's just merely this document that lists the directors and officers of the company and says, yeah, it's still operating. You have to have a one meeting of the shareholders every year, because the shareholders elect the directors. Okay, so this is a blue tab in this book, and then you'll have just a resolution. And this, you can actually do a consent resolution. This person is the sole shareholder, director, and officer. So the last thing you want to do is have a meeting with yourself, right? Call the meeting to order. Do we have a quorum? Oh yes, I'm here. Oh, okay. And so what I do is I just fill out the standard form, and they sign it and send it back, and it's called a consent resolution. Then every year the directors have to have a meeting as well, and that's a red tab. And in here there was some initialing that had to be done and everything, so it's kind of messy. But again, it can be a consent resolution, and what happens is the directors appoint the officers. Okay. Now, the only required officer for a corporation now is a president, but generally there's a secretary. Okay. And that's about it as far as the corporate minute book goes, with the exception of the one thing that I was addressing before, the notice of articles. In here is quite extensive, because the articles are the day-to-day operating instructions for a corporation. What it does is it tells you how shares are issued, how shares are sold, how meetings are held, proxies, and that sort of thing. And the last page of the articles, says no shares may be sold, transferred, or otherwise disposed of without the consent of the directors, and the directors are not required to give any reason for refusing to consent to any such sale, transfer, or disposition. So that's how the shares are restricted, the sales, and that allows it to be a private company. Enough about that. I do also want to talk about risk management in partnerships and corporations, because we're sort of looking at the fundamentals of it, but we didn't talk about the operation of it. If you have a partnership, you should have a partnership agreement. Now, the partnership agreement will not eliminate potential problems, okay? But it will have a method to resolve those disputes. And if you cannot resolve them, then it can actually ask for the matter to be given to arbitration. And if you have a corporation, you should have a shareholders agreement. Okay, partnership agreement, corporation, shareholders agreement. And I'm going to give you one anecdote that explains or demonstrates why you have to have those. I had a longtime client, a good friend, who had a marketing and advertising agency, sold it, and wanted to get into a cruise ship franchise operation. So there's a cruise ship franchisor, and they have franchisees who sell cruises, right? So he and a friend of his wanted to start one in Vancouver, and the accountant said, start as a partnership, better tax write-offs and things like that. So they started off as a partnership, and my client contacted me and he said, okay, anything we should do? And I explained that I would register the partnership for them and everything, but I told them they should have a partnership agreement, particularly because they agreed that in their office, and they would have numerous agents selling cruises, okay, they would operate from 9 to 5, 7 days a week. One of them would be there for 5 days, and the other one would be there for 5 days, and they would overlap. Okay, so there's always somebody there to manage. Anyway, the key thing though was they said if either of them did anything outside of the 9 to 5, they could use the facilities, and that income generated would be theirs and theirs alone. It would not go into the partnership. But anything generated from 9 to 5 goes into the partnership, and it gets divided equally between the two partners. So I drafted the shareholders agreement, or partnership agreement. I sent it down to them, and they said, yeah, we'll get to it. But they were finding premises, learning the franchise operation, setting up the banking, getting the utilities hooked up, going on familiarity tours. Too busy, we'll get to it later. And they never did sign it. At one point, my client has an opportunity to do a lot of work after hours and make some considerable dollars. A cruise ship that goes from Vancouver to Alaska, Holland American cruise ship, was returning and dinged a propeller. And it was going to take 2 days to fix the propeller in Vancouver. And so that meant a 7-day cruise would have to be canceled and all the money given back. And then the propeller would be fixed, and then the cruise ship would sit idle for 5 days, and they would be paying all the crew with no revenue. So my client went to Holland America and said, I want to charter the ship for 5 days. I want it to go from Vancouver to Alaska and back, no ports, okay, so you can get there and back in 5 days. And they said, great, because then they have revenue for 5 days instead of losing 7 days revenue. And the reason he did that, my client, was because he had an association that he was working with that they wanted something special for their 100th year or 50th year anniversary or whatever it was. And they wanted to do something special. And so he went to them and he said, how about a 5-day cruise to Alaska and back? And they loved it. They thought, hey, this is great. This is fantastic. The cruise ship was a smaller one, and nowadays they're like 6,000 and 7,000 people. It's like a small floating city. Back in those days, it was 1,200 passengers, and or 1,200 rooms, I guess, something like 2,000 passengers. Anyway, he sells 900 of them, just like that. Okay, and comes into the office one day. I'm in the money. And his partner says, "Oh, what's going on?" He explains that he's done this, and he's booking a whole ship, right? And she says, "Oh, great! How much money are we making?" And he says, No. I did this after hours, so it's how much money am I making? And she said, No, I think it's how much money we're making. And he said, hey, we've got this agreement. And she goes, yeah, but I don't think we signed the partnership agreement. And my client's on the phone to me, and he says, Peter, we've got this oral agreement. Obviously, that's binding, isn't it? Because oral contracts can be binding. And I said, well, not in this case, because the Partnership Act regulates partnerships. You can contract out from under those provisions, but the Partnership Act specifies that any changes have to be evidenced in writing, and you don't have a signed partnership agreement. Okay, so he sold 900 rooms, and then between then and the day that the cruise ship sailed, she was responsible for selling the other 300, and she got 50% of the profit from it. Oh, wait, no, it was only 299 that she had to sell. Let's see, he sold 900. She sold 299. That comes to 1,199. Like, what about the other room? The other room was my room because I did the charter agreement, and rather than charge legal fees, I just got him to give me a room on the ship, which I declared as income, but that was the only time I ever got to cruise and have a suite. Anyway, he did that, and he didn't have a partnership agreement, and it came back to cause him a problem. Well, after a few years, that sort of hiccup smoothed over. They're making money hand over fist, so you can forget that kind of a problem. And the accountant says, hey, time to incorporate. You're making so much money. There's tax advantages to incorporate. Remember what I said about, the advantages of a corporation? And so they said, oh, okay. And they came to me and they said, incorporate the company, please. And they said, is there anything else we should have? And I said, yes. If you have a corporation, you should have a shareholders agreement. They said, okay, prepare one. So I prepared it to them and sent it to them. Do you think they signed it? Heck, no, too busy. Get to it later. So they never signed it. And eventually, my client says, I'm tired. He didn't know it at the time, but he was coming down with cancer. He said, I'm tired. I don't want to do this anymore. I found somebody that'll buy my shares, okay? And they'll step in. They'll buy my shares. They'll become the president of the company, and then I can sell some cruises as an agent, but from my home. But I don't want to be involved anymore. And his partner said, oh, well, who's this person? And he said, oh, so-and-so. And she says, well, I want his money and we should expand the operation, but I don't think you can sell your shares because if you sell your shares, then you leave and the money comes in, but we stay the same. But if you stay and I stay and he puts in his money, then we can expand the operation. And he said, no, I want to do that. I don't want to do that. And so she said, oh, I don't think he can. And so he calls me up and he says, I can sell my shares in the company, can't I? And I opened his corporate minute book and I turned to the page in the articles and I said, no shares may be sold, transferred, or otherwise disposed of without the consent of the directors. You're a director and she's a director. You vote to sell. She votes to not allow you to sell. You have a stalemate and you cannot sell your shares. So he was stuck in the corporation. He was still getting some dividends, but it was commensurate with how much work he did, and so he basically just left. Okay, so perfect example of why, if you have a partnership agreement, you should have a partnership or a business, you should have a partnership agreement. If you have a corporation, you have a shareholders agreement. Otherwise, potential problems could crop up. Now, some problems, nothing you can do about it, but you have an arbitration clause in there, and it's resolved through private arbitration, which also fits into the course. So that's all on this little add-on video. Thank you.